Thank you, Chair, and hello, Lady Hale. I'm Dean Russell. I'm the Conservative Member of Parliament for Watford. And my question just builds on the previous excellent questions regarding the courts. And I want to understand if you think the courts have taken sufficient account of the UK's margin of appreciation when considering whether to follow Strasbourg case law. And if so, have you got any examples of where they have or perhaps have not done so, please?
I think one of the most difficult questions for us was what to do if a situation was fairly clearly one which Strasbourg would regard as being within the UK's margin of appreciation. Were we therefore to say, we're not going to interfere, we're not going to say that this is contrary to the fundamental rights, the convention rights, or were we on occasions to make up our own minds consistently with the principles of the convention as to whether it was or was not incompatible? And in a way, that takes us back to our previous discussion of when do we go further than Strasbourg would have gone? It's fairly clear that the promoters of the Human Rights Act did want us to go further and develop the convention rights on occasions. But equally, of course, we have on the whole been quite cautious about that. I can think of two examples, and both of them very sensitive examples. One was the Northern Ireland abortion case, where there was a view that Strasbourg would regard abortion as being within the margin of appreciation for member states. That is because of the great care they had taken not to interfere with abortion law in the Republic of Ireland in certain respects. So would they regard this as a matter for within the margin of appreciation? And if they would regard it as a matter within the margin of appreciation, what was our role? Were we to make up our own minds, or were we to say, hands off, we're not going to do anything? Well, the majority of us decided that we would be abdicating the responsibility which the Human Rights Act gave us if we did not try and make up our own minds about the situation, because the Human Rights Act says public authorities must act compatibly with the convention rights. And if the legislation obliges them to act incompatibly, well, then we make a declaration of incompatibility. So are we not ducking our responsibility if we don't make up our own minds about what the correct situation is? That's what the majority did in the Northern Ireland abortion case. The other case was the Nicklinson assisted suicide case, where again we had a question which was fairly clearly, there were some Strasbourg principles which were developing quite clearly, but they would again probably have regarded it as within the margin of appreciation for the United Kingdom. And of course, the assisted suicide case was one in which we all would have wanted Parliament to debate it thoroughly and decide it. And Parliament kept on ducking the issue, basically. And so some of us felt we had to try and supply an answer, but others felt differently. And this is the benefit of a collegiate court where differences of opinion can be voiced and argued through. Those are the two examples I can think of where the margin of appreciation has obviously caused a dilemma for the UK courts.
Oh, thank you. Excellent examples, if I may say. My next question is sort of builds around that, really, which was, do the courts distinguish between Strasbourg case law in cases where the UK was a party and case law where the UK was not a party to that litigation?
I'm not sure that one does so in a very formal way. We are much more likely to distinguish between Strasbourg decisions which are Grand Chamber decisions and decisions which are just that of a particular chamber. But that's a much clearer distinction. If something has been decided by a Grand Chamber, we are much more likely to follow it than if it is something that has been decided by a chamber. And there are thousands and thousands of Strasbourg decisions, and some of the chamber decisions seem quite surprising or difficult to understand, or only explicable in the context of the particular country from which they're coming, that sort of thing. So that's the distinction I would draw, rather than the country that it came from. But obviously there are a whole raft of cases from Eastern European countries where the context is so different from the context in the United Kingdom that they're of less assistance than ones that come from countries where the context is comparatively